The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show. So here you go. Today we have Ginny Whitman with the Volunteer Lawyers Project, VLPCincinnati.org, and of course, as always, Don Moore and Dan Moore at the Moore Law Firm, moorelaw.com. You can find all of that at fox19.com by clicking on the Moore Law tab. We're back for just a few more minutes, and we want to go right away to the phones to Yvonne in Cincinnati. Yvonne, you had an issue after you filed bankruptcy, right?
Yes.
Can you tell me a little bit more about it?
I filed bankruptcy in June of this year. While filing, the company still continued to garnish my wages. I informed my lawyer that it was still being taken out. After discharge, he had called and asked the other company if they were going to refund my money. They told him no, and he wants me to give him more money to go after the company.
Is there anything you might suggest, Ginny?
You know, I don't really know the answer. My first response would have been to call your lawyer again. If what's happening is not due to something that he failed to do, then I think you're probably going to have to pay your lawyer more money to pursue it. If he failed to do something to notify the company during the course of the bankruptcy, then you might tell him or ask him to go ahead and sort of correct the problem. But I don't know any other way for him to compel the company to give you your money back other than probably trying to negotiate a settlement or filing a suit against them.
You know, don't you wonder, Jenny, this is not an area that I practice in, but, but don't you wonder if there's a legitimate chance of collection, that they may get somebody who does collection work to go back against that company and say, look, you've taken money you shouldn't take and you owe it back? Well,
yes, very, very possibly you could. And most collection lawyers operate on a contingency.
That's right.
They will take a percentage of whatever they are able to collect for you. Yeah.
So Yvonne, if your calls to your the one who handled the bankruptcy for you, doesn't cut it, you might just call another lawyer or two just to see if they'll take it on a contingency fee basis. Look for somebody who does collections work, and perhaps they'll just take a percentage. Best of luck to you on that.
Okay. Let's get to the next call. We have Manon in Cincinnati. Good morning.
Good morning.
Please go right ahead with your question.
Okay, my question is, my daughter had a particular case going on Mother's Day of 2012 where she stepped in a water hole that should have had a cap on it in a grassy area by the sidewalk. I found out who the property owners were, contacted a lawyer, and they accepted the case. And then a few months later, they're telling us that there is nothing that can be done. The company is denying liability. So I said at that point, is it over with? You know, because it seems to me that it should have been some other direction that we could have taken with this at that point. Mm-hmm. You know, so my question is, what is my daughter's rights regarding this?
Don?
Well, actually, this is a good question, and it comes up a lot. If you've had a regular personal injury lawyer, somebody who does that type of work on a regular basis, evaluate the case, and they say, it's just not a case, we're not interested, there's nothing we can do, get a second opinion. And you can get a second opinion, won't cost you anything. Like we said just a few minutes ago, a phone call doesn't cost anything. First office visit, if they'll sit down and talk with you, doesn't cost anything, and they'll only collect on a percentage basis. However, they have to believe they've got a good shot at winning. We had a show not long ago, Slip, Trip, and Fall. That's the category this case falls into. Those are tough cases. If you get a second or a third opinion and you get 2 or 3 no's, then I'd say she's just out of luck. They're not going to be able to do anything for her.
Okay. We have time for another call. Let's go to David in Norwood. Go ahead, David.
Yes. In 1991, I had carpal tunnel operations on both hands due to repetitive motion at work. And now my carpal tunnel has come back to my right hand. Do I still have a claim on this?
You know, the best thing I think would be to go back and contact the lawyer who did the workers' comp claim for you in the first place. If it's a continuation of the same issue, there's a chance that you can go back. A workers' comp specialist is the one who's going to be able to help you with that. And that's something that I don't do. I know a lot of lawyers who do, and you just need to talk to somebody in workers' comp. Do you have anything to add to that, Jenny?
No, that's one area that legal aid doesn't do either, so we would not be able to help you with that sort of
right,
problem.
And if a person doesn't have money for workers' comp, they don't need money because that's also a percentage, isn't it?
Yes, it is.
A contingency fee.
Yes, it is.
So David, best of luck on that. I'd call the lawyer back that handled the workers' comp for you in the first place and see what they say.
Okay, I think we can get one more call in. Gary? No, we don't. But, you know, Jenny, you had mentioned earlier something about when people, you know, they don't qualify. A lot of people have a lot of debt, but they don't qualify for bankruptcy. Right. And I think that was something you wanted to tell them what they might do about that before we go today.
Well, first of all, Legal Aid gets an enormous number of calls from people who need help with bankruptcy, and we can only help a very small number of them. Right now, it's limited to military families, some clients that refer to us through job readiness agencies, and if you're already a client of Legal Aid. But we were getting a lot of calls from elderly and disabled individuals who were being hounded by creditors, telephone calls. And this all started with one woman who told me that every time the phone rang, her sick husband would just almost have a heart attack. So this family really didn't need bankruptcy. They had no income other than Social Security disability, which is exempt from collection. They could have owed someone $1 million and nobody can touch your Social Security. They didn't own a car, they didn't own a home, they had no property. They're basically uncollectible. So what I did in that case is I wrote the creditors a letter and said, quit calling them. And that's turned into a little bit of a practice for me at Legal Aid, and in many, many cases, it's successful.
Stop the creditor harassment. Is that right?
Stop the creditor harassment, right, without having to file bankruptcy.
All right.
Great.
Well, Jenny, thanks for joining us today.
Yeah, thank you very much.
Always good to see you on a Monday morning.
And you as well.
And join us next week when we will be talking about holiday traffic accidents. I hope nobody's involved in those, but unfortunately somebody will be. We'll be here at 9:30 next Monday.